Thanks for joining us today for Jennifer Schaus and Associates in our Webinar Wednesday program. We are coming to you live from Washington, D.C. Our webinars are every Wednesday and are provided complimentary. They're recorded and can be downloaded from our website and YouTube channel, which now holds over 300 of our government contracting webinars. In the interest of time, we do not take questions, so if you have questions for our speaker, we will have his information on the last slide of the presentation today. A special thanks to our educational sponsor, the National Veterans Small Business Coalition, for making these webinars possible. The NVSBC is the largest nonprofit trade association for veterans. Please visit their website for more information. Okay, and now a little bit about us. We work with the U.S. federal government contractors, including product, service, and software firms. Our services range from market analysis reports to contract vehicles and compliance. More information is on our website. We will also be hosting a COVID-19 and the federal government contracting impact webinar this Friday, March 20th at 1 p.m. You can please, if you would like to attend, please head over to our website under the Events tab. We also have opportunities for your organization to advertise in our newsletter. We now reach over 17,000 subscribers, and this includes both contractors and government. Contact us for pricing information with the email shown on your screen. Okay, and now to introduce our speaker, Joshua Duvall. Welcome, Joshua. It is great to have you here with us today, and I'll turn the floor over to you.
All right, thank you so much, and welcome everyone to this bid protest intervening to defend your award webinar. I guess you can roll to the next slide. My name is Joshua Duvall, and I'm the managing partner and founder at Mattrellis Edwards, a government contracts and cybersecurity law firm. And can you go to the next slide, please? And so, just as a brief background, I don't want to spend too much time talking about the nuance of bid protests. There were other Wednesday webinar from J. Schaus and Associates that I believe are on YouTube right now that sort of go over GAO protests in general. But suffice to say, you really have three forms to file a protest, and they're really allowed in GAO in the Court of Federal Claims. In the agency, the intervention isn't a matter of right. It's not in the FAR, but agency contracting personnel might allow you to submit comments. And so for the bulk of the conversation today, we're really going to focus on the Government Accountability Office interveners, because that is, as you know, an expeditious form for protest, and by and large, most protests are filed at GAO. The Court of Federal Claims is a court residing in Washington, D.C., in the National Courts Building. The procedures there are court procedures, unlike GAO, which is somewhat informal, and so there's a little bit more nuance there, but let's switch to the next slide. And so when we're dealing with a protest, some folks I've talked to that, whether you're a small business and you've really been focusing on, working with primes as subcontractors, your company's growing, and you're getting into a position now where you're going after these prime contracts, and lo and behold, you've submitted a proposal, you've waited quite some time, and then you get the notice of award, and you're excited that, you've got an opportunity to have a prime contract, get some past performance, and really, jumpstart the next phase of growth as a government contractor, and then you get a notice. So when an award is protested at GAO, for example, you will receive notice that it was protested under the GAO's bid protest regulations. And the party protesting is an interested party, which is an actual or prospective bidder or offerer who has a direct economic interest. And so what we're thinking about with this is, twofold. One, it's one of your competitors, but also sort of intertwined with interested party status is this idea that protesters must also be able to demonstrate competitive prejudice. So if you've come off of the heels of a debriefing, for example, as an awardee under a FAR Part 15 procurement, it's advisable to request a debriefing. Not only are you going to get an opportunity to kind of learn about what happened, but you're still building relationships with agency personnel. You might find out how many competitors there were, and the agency might even furnish you with the ranking. As the awardee, you might get a little bit more information. Under the FAR, only prescribes the minimum requirements under FAR 15506D. And so the agency might be a little bit more inclined to give you that information. But if you learn that the protester, for example, is one of the folks at the end of the line, maybe fifth or sixth out of 7 offerors, they're going to have a hard time showing this standing aspect, which is somewhat tied to interested party status, but that's for another webinar, so to speak. But that gives you an idea of who's going to be challenging the award. They've got to be an interested party. And at the next slide, at the Court of Federal Claims, it's generally the same definition under the Tucker Act. There's a case that construed the definition of interested party standing in accordance with CICA, which is where the GAO's bid protest regulations are really given teeth. So, and now moving to what happens. So the next slide here, this is important. You might be thinking you've won the award, but do you really understand what happens? Well, if it's timely filed at the Government Accountability Office, there's going to be a situation where the award, the performance is stayed. And so if you have employees ready to roll and the protester has filed a timely protest, the agency is not going to allow you to commence performance because the CICA stay has been triggered automatically by the timely filing of that protest. So in a situation where a debriefing was timely requested and therefore required under the FAR, the protester would have 5 days to file the protest after the debriefing ends. Now, on the other hand, at the Court of Federal Claims, there isn't a CICA stay, so the protester is going to either file a motion for a TRO and preliminary injunction seeking the court to enjoin performance preliminarily until the protest is resolved, or at that point, the Department of Justice attorneys are going to be working with agency counsel and to try to get an agreement to voluntarily stay performance during the protest. So there's a difference there in procedure, but like I said earlier, we're focusing really on GAO protests. So if that protest is timely filed, you're not going to be able to commence performance, and that can have a lot of impact on cash flow. If you've already hired the folks and you're ready to go, you're just kind of sitting there waiting until this protest ends before the agency can move along forward. And so with that, let's sort of move to the next slide here. When we're thinking about intervening, again, the right to intervene is set out in GAO's bid protest regulations and also in the Court of Federal Claims rules of procedure. GAO's protest regulations are 4 CFR Part 21, and we're talking about with respect to the Court of Federal Claims Rule 24. When intervening is an option, it's generally advisable to intervene. The government understands that awardees have an interest in keeping the award. Obviously, the government chose the awardee for a reason, whether they believe that they offer the best value or their technical approach is superior to the competition. And so that's sort of expected. You're at I don't want to say the catbird seat, but you're in a position where the agency is going to welcome that, usually, that approach. And so, like I said earlier, you can intervene at both GAO and COPSI. And the definition, if we want to move to the next slide here, at GAO is the awardee if the award has been made. And if no award has been made, all bidders and offerers who appear to have a substantial prospect of receiving the award. So if you're the awardee, you have the right under GAO's bid protest regulations to intervene. You'll find out via the notice under 4 CFR 21.3a that is given to you after the protester files a protest. You'll be alerted that there's been a protest lodged at GAO. Conversely, if we go to the next slide, at the Court of Federal Claims, the intervener must file a motion with the court claiming an interest to the property or transaction. So it's slightly different. Like I said earlier, we're dealing with a federal court as opposed to the Government Accountability Office, which is in part of the legislative arm of the U.S. government. And so GAO's protest decisions are mere recommendations, but when you get to a court, you have the weight of the judicial branch behind it. And so, again, let's continue on here to really focus in on the substance of today's conversation, which is intervening to defend your award. If we can go to the next slide. Again, agencies anticipate that the awardees will want to intervene. You've won an award if it's substantial. You can sort of at least anticipate whether or not you will be protested. So, for example, under FAR Part 15 procurements, as I mentioned earlier, awardees and unsuccessful offerors will have the right to receive a debriefing. Now, if it's a rather large contract, 50, 60, 80, $100 million, and today's competition for a government contract is quite fierce. And so one thing that awardees should be thinking is that as the dollar value raises generally, but not always, you might see that award get protested. And so agencies know this, and they know that it's part of the acquisition process that GAO protests are generally filed. As I mentioned earlier, the lion's share of protests end up at the Government Accountability Office. And the primary reason for intervening is to protect your win. In many instances, the protester is going to be challenging your technical approach, why the agency provided you with an exceptional rating, why you're accredited with strengths. And as the intervener, you'll have the ability, because your technical approach better than the government would, you're the one that furnished it in your proposal, to sort of rebut those arguments and say, no, this technical approach was superior and we were rightly credited with strengths for it. With respect to intervening, it's unlike filing a protest in one respect, in that the protester is filing their initial protest, and when the agency submits their comments, their agency report, the protester is filing comments and supplementing their protest with new grounds uncovered during that period of time where you're reviewing the agency record. For interveners, there's really two paths. There's this sort of active intervention and passive. Passive is more just monitoring the situation. It's a way folks use it to sort of keep costs down. If the protest is filed and it's untimely, and the agency understands that it's timely and they're going to be filing a motion to dismiss, that might be something where at least you have eyes underneath the hood and you know what's going on. Or if, for example, the protester is unaware of the uphill battle that it is to show that they're really next in line for award or have a substantial chance of winning the award if the protest was sustained. If they're, like I said, 7th out of 8, you might be thinking that's going to be challenging. We just want to, stand here and rebut if we need to, but let the agency, make their motion dismiss. But if it's a closer procurement and it really went to a best value trade-off, now you're in a situation where the protester is potentially challenging your past performance, your technical approach, how the agency made its evaluation. Did they stay within the confines of Section M? Did they utilize unstated evaluation criteria? So when you're under the hood as an intervener, you can be a little bit more active in that respect. And not only are you have an ability to file briefs at GAO, but also you're acting as sort of a resource to agency counsel. Some of these agencies handle a lot of protests, and they're very familiar with GAO protest decisions and the basis on which those decisions are made. Some agencies don't necessarily see a lot of protests, and so they might be more inclined to ask to welcome the help of the intervener. And other times, agencies are very overworked. The folks that work for the government are hardworking and diligent, and they might be inclined to take corrective action if they've got a full plate or if it seems like it could go either way. So when you're intervening, you're not necessarily driving the protest like a protester would. You really have two paths. And if we can go to the next slide. And so one other reason that intervening is a good idea is if protester files a protest with outside counsel, in many instances, they're going to request a protective order. And if you're the intervener, you're only going to be receiving redacted copies of this protest and agency documents. You're not going to be able to see everything that's going on. If you've intervened with counsel, on the other hand, your outside counsel will be permitted to gain access to the protective order, including any consultants they may use. If they have cost or pricing experts, those folks might also be granted access to the protective order. And although your outside counsel and outside experts won't be able to share with you the protected information, they'll at least have an idea of what's going on. And so you have some sort of comfort in knowing that you've got eyes on the actual protest. Another reason that intervening is helpful is the ability to help protect your own confidential and proprietary information. This is also true for if the protest goes all the way through and GAO issues an opinion, you have the ability to sort of protect that. And one thing to add when you're talking about intervening and getting unredacted copies of protests, and you're also in a position to help limit what's shown and sway the agency's corrective action. So if we go to the next slide here, it says awardees' interests may not entirely align with the agency's interests. As I mentioned earlier, the agency might be inclined, for whatever reason, to either not make a specific argument, or might be leaning towards corrective action. In those type of instances, their interest isn't necessarily aligned with yours, although in many cases they want the protester to go away so they can commence performance. They've got a schedule to keep, and they've got an acquisition to sort of shepherd through the process. So if that's the case, if you're in a position where you've intervened, not only are you able to make the arguments that for whatever reason the government decides to not make, but also to sway against maybe taking corrective action. If, on the other hand, the agency decides that it is in its interest to take voluntary corrective action, the intervener will have an opportunity to potentially have some input into the scope of that. And so that's another really beneficial impact for having your intervening in protest, because as I mentioned earlier, if the protest was timely filed at the Government Accountability Office, it triggers the automatic stay, so the seek a stay of performance. So the agency is not allowed to commence performance. So you've got folks sitting on the sidelines, so to speak, if you're waiting for that to happen. In addition, sort of going back to my earlier point about that agency personnel might have various reasons for taking different approaches. Some might be steeped in bid protest regulation. They understand and they handle a lot of protests. Maybe they have a designated protest counsel, whereas other agency officials or agencies don't have nearly as many protests going through. You're able also, as an intervener, to sort of lend additional support to the agency personnel, whether you're filing briefs or not. At least you can harmonize approach to defending the protest. One other thing that I didn't mention earlier is motions to dismiss. So when a protest is filed, if it is untimely, or if we don't think the protester has standing, or for whatever other reason, maybe there wasn't the protest was too speculative, by intervening, you're either in a position to either file your own reasons for motions to dismiss, or harmonizing your thoughts with the agencies as they file their motion to dismiss. That can be good for a number of reasons. It can limit the scope of the protest, which will then in turn limit the agency report, which is a good thing if you're the intervener, because the protester will have less information upon which to make comments and supplemental protest grounds. And so sort of coming back to this final slide here, when we're thinking about intervening, it's generally a good idea to intervene if you're the awardee. As I mentioned earlier, if it's a FAR Part 15 procurement and you've received a debriefing, you've already established a relationship with the agency contracting personnel. But if you suspect that the award is large enough that it might give rise to a protest, you've already started the process of learning some of the reasons for why the agency made its decision, and sort of working together in anticipation, so to speak, of being protested. Again, you're also in a position to defend your win and rebut some of the arguments that are challenging your technical approach. While the agency attorneys are well versed and they may be well versed in protest, you're the one that understands your technical approach better, and you're in a position to defend the the strengths of it and the merits of your approach as the reasons for why the agency credited you with more strengths over the protester. And so that's something to keep in mind. Again, you're also in a position to protect confidential information, and besides limiting the record and shaping potentially the scope of corrective action, you're adding another force behind, that would give GAO reason to think, okay, this really doesn't give rise to a sustain. Should be to deny, not sustain, but we're convincing the GAO to deny the protest. You can move on or to avoid the corrective action with respect to agency personnel. And so as you can see, whether you're filing a GAO, protest has been filed, a GAO or the Court of Federal Claims, you're really in a position as the awardee, because you have an interest in the procurement, to intervene. It's a little bit more mechanical at the Court of Federal Claims. It is a federal court and it requires a motion, and court procedures are going to be filed. GAO, like I mentioned earlier, it's a relatively inexpensive and expeditious process. Your protests are filed through what is now GAO's electronic protest docketing system. And so you log on to epdas.gao.gov, and you'll be able to create an account. And whether you use outside counsel, they'll have an account usually to file their intervention, so to speak. And so if you don't intervene, that's fine. Some folks, like I said, you have this active approach versus passive approach. It's a way of keeping costs down, but ultimately, if you're the awardee and you've won a contract, you've got it unless there were errors in the procurement that would give rise to either the agency taking voluntary corrective action or having GAO sustain the protester's protest, which would again sort of restart the process in some manner, because you're now waiting even longer to get your folks to work and sort of in the process of now contract administration, submitting bills to the government, performing work, getting your deliverables. But until that happens, you're really just sitting on the sidelines if you're in a situation, as I mentioned earlier, where the protest timeliness triggered the seek a stay of performance. And so with that, I think that's a quick rundown of the reasons for intervening in protests and why contractors should think about doing so if you're the awardee. Again, it's a right that you have both at GAO and the Court of Federal Claims. And so it's in many instances welcomed by the agencies, if not anticipated. And so with that, I really want to thank everyone for paying attention to this webinar. Try to keep it about 20 minutes long here today. I know everyone's got stuff to do. So with that, I will turn it back over to my colleague here at J. Schaus and Associates. So thank you.
Thank you, Joshua, for a great presentation and sharing your time with us. Thanks to everyone who joined us. The recording will be on our website and YouTube channel within the next 24 hours. Please join us this Friday as we cover each part of the FAR, and join us next Wednesday for more hot topics in federal contracting.